Welcome to Probate Weekly. And sometimes the goal is to avoid probate. And in California, it's definitely worth having the right person to help you make sure that your plan keeps you out of probate court. I'm really excited to have today Beverly Hills attorney David Soffer on the topic of estate planning primarily. David, thank you for joining us today.
Oh, my pleasure. Thanks for having me.
So I was looking at probate as somebody didn't do their job. Either the decedent didn't plan ahead properly, or the attorney didn't make the right plan, or the decedent and attorney didn't work out together to get the plan effectuated. So proper estate planning is important. Talk about why that's the practice that you focus in on.
Absolutely. So we do at our firm both estate planning and probate and post-death administration. And so there are often times where somebody's passed away who's done proper planning and or done the bulk of the work that they need to do, for instance, funding their trust and getting assets into the name of the trust during life. But life happens. And the things are unexpected at times, and assets come and go, accounts open and close, and sometimes not everything is accounted for. And there are frequently times where something falls through the cracks, and this is why we do probate as well. Even if you have close to the most buttoned up plan, not everything is always perfect.
So obviously, there are things that you can't avoid, and I always feel like if there's enough money involved, somebody's going to sue you anyhow. But as a general rule, what are maybe one or two of the most common mistakes you see people make in not preparing? Maybe they have a plan of sorts, but they didn't plan properly. What are one or two of the key mistakes that you see that lead people to not having the outcome they planned on?
Yeah, absolutely. Well, I think I can start from the most basic, which is just not planning at all.
Hmm.
No documents whatsoever, or very bare bones documents that really haven't been well thought through are often going to lead to disasters. I'm not going to cast aspersions on the do-it-yourself stuff, but typically you get what you pay for.
Right.
Beyond that, I think something that might come as a bit of a surprise, but frequently, even when you have the most straightforward plan, something like everything to each other and then the kids equally, there are decisions around the margins that really require some thought. So what I'm talking about specifically is frequently kids will be named as trustees as after the parents go. Well, I have seen that create friction between siblings when it doesn't otherwise exist. Or even more to the point, naming one of the kids, who everybody agrees is the one who is good at this, naming one kid as in charge of everybody's money, even for a short amount of time, can absolutely create a dynamic that will have permanent damage and friction throughout the relationship for the rest of their lives. So that's something that I always want to make sure that clients are really being thoughtful about.
Right. Yeah, that's when I see it's very subtle, but oftentimes the child most qualified in terms of technology or techniques or characteristics is the worst person to do it because they may not have the relationship with the other siblings or
Yeah.
the time to communicate properly with the siblings. And the other ones maybe who are less capable but are honest and communicative might be better. So it's an interesting choice. So how do you advise clients when they advise, well, I have this sibling who's a successful businessman. I have these other two are have nice lives and all, but I want the businessman to be in charge. And might the businessman successful child not be on best terms with the other siblings, and can that not lead to all kinds of problems?
Absolutely. So we talk through this at length, and frequently we just want to. I tell them, this is not my family. I don't know the dynamic. I don't know your kids like you do, and so if this is the right choice, this is the right choice. However, just consider that you may be setting them up for something that is avoidable, and let's consider potentially a neutral. What about a professional trustee? What about a family member or an advisor who is not directly related to the situation at hand? What about naming them all together if putting one in charge of the others is going to be problematic? I also counsel clients a lot about managing expectations and communication. Not that it's required. And sometimes, again, back to not knowing the family dynamic and not knowing whether that's going to be detrimental. But telling everybody what they think is going to happen while they're alive and what to expect really goes a long way in preventing friction in the future.
I know there are some attorneys who advise to provide the minimum required, and other ones who want to lay it all out. So if there's any objections, it comes out right away. Meaning, I believe when there's a trust involved, all members of the trust are all who would be heirs if it was intestate are required to be noticed that there is now an irrevocable trust, and then they can request a copy of it, and then they'll get it or not. So there's a process there. And other attorneys just say, just send them the whole thing right away, so there's no dispute. So where do you fall in that camp, or is it a case-by-case decision?
The latter for us, because we are a smaller, more boutique firm that really focuses on individual matters and try to be a little bit more bespoke with every matter. I do lean towards the camp of send it to them because they can get it anyway. It'll extend the statute of limitations, but there might be very good reasons not to. It might create the hubbub that you're trying to avoid by sending everybody everything. And so we try to be situation specific.
Yeah, it seems like that's the best policy because I can make cases for both being better. As a realtor, I've been in both cases where I'm always on the wrong one of those, by the way. Just I get the heir who doesn't get the copy of it, but he wants it. I get the other one who gave out too much and it upset the other siblings. So it seems like I'm always on the wrong end of that deal. One of the most common problems as a real estate agent, obviously I get involved in this piece of it more than anything else, is I have a customer who has a world-class plan. It actually shimmers gold up to the heavens. There's unicorns and rainbows over it. They pull it out, because I'll say, hey, I noticed that you hold title as Mary and David Smith. Do you not have a trust? Oh, no, we have one. And they pull out this beautiful binder with all kinds of papers flowing. And they open it. The top page is the deed of trust never executed and all the other instructions. So it just seems like the number one area that causes problems, of course, I'm in that part of it, is the real estate not being funded properly. Talk about that problem and what you do to advise clients to avoid that problem, or what you do to help them.
Yes, of course. It's common, it's frequent. I think it starts with educating the client, and that certainly starts with the attorney, to tell them that trusts work best when they are funded, when the assets are owned in the name of the trust. And really, it is not an arduous process to accomplish that. Certainly with the real estate, in my opinion, that should be part of the preparation of the trust in the first place. But this is not a surprise to me that this happens frequently. Clients are quick to feel like when they are done with signing their trust, they are done with estate planning. And truly, it's a lifelong process, right? And just like life is fluid and flexible and things change, so too does their estate plan. And it's a marriage between the words on the page, the titling of the assets, the family dynamic, the ownership. There's all sorts of things that go into what the actual estate plan is at the end of the day. And so having a beautiful gold-plated estate plan is only one piece. It's only as effective as the rest. What do we do? Well, certainly we have all sorts of trusts and estates that we administer where we didn't write the plan or we weren't involved in the planning. And so we have to clean up messes constantly. That for whatever reason that type of matter often seeks us because it needs some, what I'll say, an elegant solution to a complex problem. Of course, at our disposal is what's called a Hagstad provision, or sometimes it's called an 850 petition. This is applying to the court to avoid probate altogether and ask for the judge to transfer that real estate that wasn't in the trust but is supposed to be into the trust without a full probate. Very successful historically. Anecdotally, we found actually that we think that the court is getting a little bit stricter on granting these. They are starting to push back just a little bit. So I wouldn't say they are complete guarantees. And there have been times, even when they were routinely successful, that there are pragmatic problems with filing a Hagstad to clean this up. Sometimes we have filed a probate instead, and I can explain why. Oftentimes what we will get is the trustee comes to us, says, the house isn't in the trust, but I already have an offer. I'm ready to sell. What do? I can't sign this. And our answer frequently is if we prepare a Hagstad petition, we're going to get a hearing 70 days from now, and you're going to lose
at best, I think.
That's right.
I would say 6 months, but it
depends on the county, as opposed to a hearing for probate, which is supposed to be within 30 days and will get you the authority that you need to sell. And there are times where we go down that route. They will wait. We are fully transparent with fees and the process, and they've decided that's the better choice for the estate or the trust.
Yeah, that's a common misconception. It's interesting. You're the first attorney that's picked up on that I've heard, because they'll often say, well, yeah, we can just do a Hexted. Yeah, that's still is 6 months. The attorney's fees are not that much less than a probate. You
Depends,
still got to
but
go to a
yes.
hearing. You got to
Yep,
publicize things. Somebody can still object if they're going to object. If they're not going to
absolutely.
object, then it's likely split. But still 6 months, 7 months before it gets done. In
Right.
a probate, you can be done in 35, 40 days,
Yeah,
theoretically.
we try to be as practical as possible with what's in front of us,
Yeah.
and there are lots of ways to solve problems.
So we talked about the not having a plan. We talked about not funding a plan. Are there any particular issues that you see in people who have plans that also lead problems down the road when it comes time to administer? Any other that jump out the page?
I do. I can tell you, and this again may not be something that one would imagine immediately, but dividing your estate in small percentages between a million different beneficiaries gives every single one of those beneficiaries rights to information, rights to ongoing administration of the trust, which can become incredibly cumbersome for the trustee, for the attorney, for everybody involved, as opposed to potentially if we are truly trying to honor people with small bequests that would represent it might be so much more economical and practical to just name them for a dollar amount or a set amount at which point they are then satisfied once they receive that amount and no ongoing rights or
Right,
rights to information.
right. Because inevitably there's some more costs involved before the final is divvied up, and they always end up with a little bit less than expected.
Yep.
And even if it's a little less, it's always less, and they're upset. And yeah, that's interesting. And so do you advise them to have a fixed amount and maybe some sort of a administrator's discretion at the end to, if there's money left over, to use their own judgment on the rest, or
We always need a provision that says the rest goes here. And even if the rest is divided, but what I'm really trying to avoid is the rest getting divided into a million different pieces.
correct?
The rest could be 1, 2, 3 beneficiaries, but once we start getting into so many more, it becomes, I think, counterproductive.
Got it. Now, do you also deal with estate litigation? I mean, I guess there's some routine litigation, but when there's actual major litigation, do you handle litigation, or somebody else in your firm handle that? Or
We do not. We try to stay outside of the contested fights, but it's not always possible. Unfortunately, not all the families that come across our desk are super harmonious. And there are times it depends. If something comes to me as litigation, we'll refer it right out. If something is brewing and we are already involved in the administration and it turns into litigation, oftentimes just relationship wise, we will co-counsel or bring somebody in to help.
I think clients don't often understand there's two different aspects, right? There's the estate expertise and the client expertise that you have, but oftentimes detailed involved litigation is a separate kind of character trait. There's litigators who can litigate anything pretty much, and or litigate a wide range of things, and they're just a different breed. These
They
are my
are.
experience.
They are. I focus much more of my practice also on trying my best to help families achieve goals rather than trying to, and not that there is great service and great need for litigation. It is just not where I want to spend my time.
Got it. Yeah, it's interesting you say that, because I have a colleague who's specialized like I do in probate, and to build her business, she added another, which she thought was related, and commonly pitched to real estate agents as related field in divorce real estate. And I said, you know what? I'm married 39 years, one day at a time, hanging on by my fingernails. I don't need to deal with more divorced people in my life. I have friends who are divorced. We have all kinds of friends who are divorced in various stages. I don't need any more. Not, I wish them well, and I like to help them, but I just don't want to put myself in that position. And I can imagine litigation, I think, is a different breed that some people love it and thrive on it, but it's just not
Absolutely.
I don't see that.
Absolutely. And again, I think there is a great need. In fact, I think that the need is going up with the amount of estates and trusts that are going to be needed to be administered in the next decade plus. We're going to see more and more litigation, but we try to be proactive even in our planning stages. By administering, we tend to learn, and it influences the way we draft in our estate planning so as to be practical and litigation avoidant.
So when you do, just help me define the term estate administration, are you advising the administrators, the successor trustee, or do you actually perform the acts as the successor trustee on behalf of the estate and do the actual work of, marshaling resources and distributing them?
No, we like to stay in our lane. We represent trustees and executors and fiduciaries. And so much of our world is private without court involvement, where we are settling trusts that don't need probate court intervention. Our clients are frequently professionals, so we represent banks and trust companies, but I would actually say the majority of them are lay people. The friend, the kid, the surviving spouse, the sibling, you name it. And they look to us to really guide them because it's their first time through this process. And so we try to handhold them throughout.
One area that, as a real estate agent in this business now for 6 years, focused 100% on it, so I do quite a bit, that I just see a lack is you mentioned the fiduciaries or a professional to assist the estate so that rather than successor trustee having to be a sibling or a friend or family member, that there's somebody who does that work, because it really is work. When you take a $40 million estate and marshal it and manage it and then distribute the resources, it's like you're running a business that's a $40 million asset business. And while you might think your child can handle that, most people, you would never hire somebody typically to do that job unless they were doing it all the time. And so I find two things. One, unmet need for more professional fiduciaries, and second, there's so few of them in the business. Like they all tend to be older, more of them are aging out of the industry. I don't see young people going into it. So what do you do when you see an estate needs that? How quick are you to bring somebody in? Do you have your own Rolodex of people that you work with regularly?
We do. We absolutely do. We have our half a dozen that we rely on frequently. I don't want to work with everybody. I don't think everybody wants to work with me, but we do. We have our go-tos, and a lot of it is a personality fit or a skill set fit. And we are quick to volunteer. I tell the siblings or the kids who are nominated, this is a thankless job. This is work. You're entitled to get paid because this is going to be more work than you realize. And you don't have to do it. You don't have to say yes. It doesn't jeopardize your status as a beneficiary, if you are one, in order to step down from doing the work. There are professionals who do this and they will charge a fee, but you will be happy to pay it, I think, by the end.
I had a family member who passed and no children. So me and my sister and brother were the main heirs. And my sister called me one day saying, I'm really sorry to tell you this, but she didn't want you, I'm the oldest child, to be the administrator she asked me to be, or a successor trustee. Great.
Yeah.
Could be happier.
God bless.
Yeah, I mean, I'm here to help, and I don't want to be that sibling that's a problem, and I know what to do, so I can help and make some recommendations. But the paperwork and the forms, and there's liability involved in it, and I don't want to be the source of causing disharmony between my siblings. I mean, it is thankless work. Whatever you get paid never is worth the time, I don't think.
Absolutely correct.
And the ones who do it as professionals, God bless them. I wish there were more of them.
Yes. We try to align with younger, not always, but often we like to have younger professional fiduciaries because we also are younger in our practice, relatively speaking, to some of the older practitioners. And it tends to be the clients who look for that in their attorneys, also look for that in their professional fiduciaries, or certainly when they're considering naming somebody as a successor trustee.
If it's appropriate, I'd love to meet one or two because I'm often asked to introduce somebody, and I almost apologize when I refer a case to a fiduciary these days because they're all busy. I've never had one that ever really went. I try to get them on my podcast. They're all very, very busy. It's just interesting industry that, and I also try to encourage people who are maybe accounting background or attorneys. I think that's a great business opportunity. You have to, like everything else, manage your time and your boundaries and all that. But I just feel like it's a business with increasing demand and apparently no competition, or very low competition.
Yeah, there's more than enough work to go around.
Seems like. So let's talk about if you don't have a plan. Say California has a plan for you. It's kind of like the DMV. It just is not as customer service oriented as the Department of Motor Vehicles is. And I know you guys do probate filings and probate administration. Talk a bit about your practice as it relates to helping people who need to, for whatever reason, file a probate. Where do you fit in that role? What's a common case look like for you?
Yeah, of course. Probate, probate can come in lots of different forms and lots of different varieties. We've opened all sorts of probates right now. We have everywhere from what are called zero asset probates, meaning we've opened them for a specific purpose, even though there are no assets to probate. Sometimes it has to do with litigation, sometimes on either side. And then we have multi-million-dollar probates because the decedent didn't do proper planning, and we have lots and lots of business interests or real estate or brokerage accounts, et cetera, that need to go through this process. But they all kind of start the same. They all start with some filings with court and us leading the client through what this means and what this looks like, who we have to notice, et cetera. We are going to absolutely try our best to think through what the court is going to look for and try to proffer it first before the court asks for it. So again, we are trying to think a couple of steps ahead and make sure that have everything accounted for. So by the time the hearing rolls around, since we've been waiting for however many weeks to get this thing going, they're ready and they are going to approve us ideally and get us moving, because what we really want to do in the probate world is start the clock ticking. We really want to we have things to get done. We have lots of things to get done, including some of the elapsing time for things like creditors and closing the estate, for that matter. That's where everybody wants to get, and we're trying to do it as efficiently as possible. Did that answer your question?
Yeah, 100%. I have a saying in real estate: there's nothing good that happens from the day I list the property until the customer gets their check. Everything is bad. In a probate, I think it's the same thing. That from the day they file, there was nothing good until they get the distribution at the end. It's all bad, expensive, time wasting, and I'm always surprised at two things: the challenge, and I know it's a challenge for the attorneys to communicate with their customers effectively about what expectations are. Because no matter how many times attorneys will say it's going to take about a year or longer, the customer just hears, "I want my money." That's all I hear.
Right.
And they cannot sign the bond forms and not sign this and not sign this for months. And you can call them every day for a month. They're not going to remember that at the end. They just want their money. It's just interesting.
Of course, you're right. Of course, you're right. Honestly, the longer a probate stays open, the more chance for something to go wrong while it's still hanging out there. Right. So
the quicker we down, COVID can hit. I've been around long enough. All these things have happened along the way.
And
I've had guardianships, conservatorships where the conservatee passed. So you go through all that, and then now you got to do probate because they didn't have a trust put together.
Oh, we've dealt with several where the executor in probate has died in the process. Yes. And that is, now we're back to needing to not start over, but redo things and change stream.
I think this is where you can tell somebody who's really in the business, because an attorney like you kind of brags about some of the problems. So the ones who aren't really appropriate for customers kind of complain about how much work it is, but really, these are badges of honors. I had one probate where it was a conservatorship. They created a trust. He passed. They left, and then we sold property as a conservative. We sold property as a trust, and they left two properties out of the trust, and we sold those back in probate. And I think those are the things that you can't ever anticipate everything, but you have to be ready. And I think, again, moving diligently. So there's obviously a fine line between, and I know I face this. Am I pushing the attorney too hard? But I know that the sooner they move, the better for them as well as the customer, right? You only get paid when it closes too. You don't get paid before. So your customer's not happy till they get paid. So you're not, by pushing the attorney, where's the fine line between me being too pushy and me being helpful and a good constant reminder?
It's a great question. I would say that ideally attorneys are mindful of the time that is ticking and don't need to be pushed in order to get things done. And I'm sure that if they are not moving, it's because they have other things that are taking their time and attention as well. But there is no reason to let things linger or deadlines to be missed. And so if you are approaching any sort of time sensitivity, absolutely push, because that is probably going to help spur everybody involved to get things done.
I know there are attorneys that take kind of a wide approach on working with vendors bank and real estate agent, obviously being one, where some say, hey, I want to go this way because we have to control the process to get the result, and others who are more let the customer decide. And I find sometimes the customer, particularly in the banking, can get really tripped up. Going to Wells Fargo to open an estate account, just boom, just blow your brains out. It's much more fun.
That's
Where are
right.
you on the spectrum? How tight or controlled do you try to keep your probate process, or how much do you leave to the discretion of the customer?
Again, I think it's situation specific. There are certain, you will like this. There are certain probates, for instance, that I won't take unless we are using a professional fiduciary, because it is too messy and I need somebody who knows what they are doing in order to
Yes.
navigate. And I simply won't take it if not.
Yes.
And there are other times where everybody seems confident, everybody seems willing, and we will say, okay, whatever you want to do, let's go. And everywhere in between. Depends on the service too.
Yeah.
A realtor in the probate world, in my world, the right one is going to make my life much easier, and the wrong one is going to make my life much harder.
Yeah.
The banking relationship is going to provide unnecessary obstacles if they'll just go to the banking center that we refer them to, because they know what to do and we can streamline this.
And it's not even I'm sure it's not even the banking center, but it's probably the branch you recommend
You
that
name
knows
it.
what to do versus every other branch is just like a nightmare transaction.
Exactly.
Yeah. Talk a little bit about, and I know attorneys have strong feelings on this subject, advances to heirs. They're like payday loans. They're expensive, but sometimes they help the customer get the case filed or started, maybe some initial funds, and also at the same time, it's really expensive money.
Yeah.
And I try to explain what those options are to customers up front. How do you advise clients who say, hey, I need $23,000 for reimbursing funeral expenses and whatever, new car, they're going to get $500,000 a year from now, but it is expensive money. It could be, 20%, 30% of the money or more. So how do you advise people on advances?
I will tell you candidly, it has not been a big part of our practice. I think just from where we sit in the field, we have rarely come across cases where that is a real necessity. And I think that if it was, it may not get to our desk because there are other attorneys who kind of work in that space a little bit more. We've encountered them before, but I don't tend to advise clients or beneficiaries about them.
Okay, so again, you're doing maybe a little higher end clientele on average.
Yeah, I think
I
that's
do find even those clients end up, the advanced companies kind of get to them on the back end of the deal. It seems like
true.
it's a lucrative business and they do well. I think those are the ones that always surprise or disappoint me, right? But they're talking to a beneficiary, or an heir, not to the administrator. So the administrator was organized enough to get to you and file the case. The heirs may not be, and so that's why they're maybe settling for those higher rate loans.
You bet. Very true.
Yeah.
And we represent one professional fiduciary on a regular basis who gets nominated by another attorney who represents the advancement company. And so there is absolutely a whole fabric of interests that are being pushed here, and everybody has their own. And so we're trying to, you have to navigate around these things.
It's funny you say that because I was on a hearing yesterday with a particular attorney representing a particular advanced company. And then today, 2 in a row on the same case, by coincidence, same attorney, both representing the same advanced company and kind of the same issue on 2 others. And so you're right, they kind of have their interests separate from my client in my case, or being the real estate agent.
Very much.
The client. So yeah, you have to be aware of that. So talk a bit about, I know that your business, just to kind of wrap up a little bit, that your business is really, focused in this area, right? That when I go to your website, I don't see that you represent DUIs. I don't see, divorces. I don't see bankruptcies. I see estate planning, estate administration, focus. The content's all related there. So you've made that decision to do that. That's a courageous decision at some point, because so many attorneys, I think to their detriment, grab onto everything and don't master anything. When did you make the decision to focus on that area? And what was that like? Must have been difficult at first.
Well, at the beginning of my career, I worked at some of the largest multinational firms that exist for a couple of years each, and realized that's not the environment that I wanted to spend my career in. And so that was when I made the decision to look for something that I could do on my own. And I had some exposure to the T&E world within one of the practices. I had done a deal with the Frank Sinatra estate, and I had some overlap with the T&E department in terms of like nonprofit, working on a nonprofit. And it was even the same time where my in-laws brought me in as the, hey, this is the new attorney in the family. Let's have him participate in our estate planning. So I got some exposure, and it was a light bulb went off and said, oh, this is something that I can do, and I can represent individuals rather than giant corporations, and I can use my mathematical bent. And so I went back and I got what's called an LLM in tax, which is an advanced degree in tax from law school, with the idea of opening up my own shop and trust and estates. And this was 3 mortgages ago, 3 kids ago, a wife that worked. I mean, there was less risk involved, but I guess in hindsight, you're right. It was a jumping with both feet, and it was either going to work or it didn't. And thankfully it did.
And so what would your advice be to attorneys who kind of holding on to 4 different things at once and struggling, time-wise, the practice, you can't really organize it effectively. I just see that, and I want to give them career advice. So let's take the opportunity in a non-threatening way. How would you advise an attorney who's struggling a little bit financially? He's doing business, but he's kind of got his hands in 3 or 4 different things, not mastering any or creating brand space in his clients' heads about any of in particular, that why they should consider specializing.
Well, I personally believe that the best marketing any attorney can do is do good work for somebody and be reasonable to work with. And so the more you know about one particular field and practice area, you become that person's guy or girl, and then they speak to their friends and their inner circle, and word gets out that you are the person to go to in this particular niche. And that to me makes the most sense in the world. Dive as deep as you can to be really good at one thing.
That's great career advice. Last piece of advice for other attorneys is, if you're able to share, what percentage of your time or energy do you put into business development as opposed to the practice of law, right? You're individual shop and you partner, but it's not like you're a huge firm.
No.
But even there, they do business development. So we kind of talk about how you allocate your time on that.
Sure. So we have 4 attorneys here and some staff as well, paralegals and assistants. But truly, I am the sole rainmaker for the most part, the sole business generator. And so I do spend a lot of time on business development, but thankfully almost everybody needs what we do in some respect, in some way, in some shape or form. And so we get referrals from all sorts of various sources. And I think that probably half of my time during a day is spent on what I would call non-billable, whether it's networking or business generation, or even speaking to prospects and clients, speaking to those referral sources, et cetera. There is quite a because we have to play the long game. What we know what we have today, we don't know what we have tomorrow. Yeah. So sometimes it's laying down track.
Well, for the record, I appreciate being one of the non-billable hours in your day. I really appreciate your time, but more importantly, I appreciate educating us on state administration. I think also you've given us some good business advice. For those who want more information, sofferlawgroup.com is the website, and I have a link there because it has his handsome face on the front. Down below, we have the contact information, 310-284-7306, or reach out to me. Be glad to forward it as well. David, thank you so much for your time today, and thank you for giving us really some good business insights to help us on how to be more effective in all of our businesses.
Thank you, Bill. Thanks for having me.
Fantastic. And for the rest of you, this is Probate Weekly. We do this every week. Interview top attorneys, mostly, often vendors, practitioners in the business of probate to learn how to do our business better, serve our customers better. If you want to be interviewed or you know somebody should be, feel free to send that information along. Call, text, or email. Subscribe if you like this. As always, make today your best day ever. Thanks.